Hello, my name is Major Mike Webb. There is an old adage that only a fool represents himself in court, and viewing the statistics of success in pro se litigation or cases in which a party, plaintiff, or defendant is not represented by legal counsel, the statistics are truly grim. And in April 2019, according to the American Bar Association, a petition for certiorari brought by a certain William Bond, a pro se litigant with a formidable assistance team of David Boies of the law firm of Boies, Schiller, Flexner, and former Seventh Circuit Court Justice Richard Posner, a senior lecturer at the University of Chicago Law School and known as one of the most influential legal scholars in the nation, on the mistreatment of unrepresented litigants in the federal judiciary, a truly liberal cause, and an issue that was of such importance that Judge Posner resigned from the bench, was denied a case in which Bond had accused 3 federal judges of attempting to quash his case. Bond had proceeded without counsel or assistance until he arrived at the Fourth Circuit, and they had affirmed the dismissal of the trial court. However, on November 3rd, while the election for the governor in New Jersey was still being decided because of a delay caused by a malfunctioning voting machine, several malfunctioning voting machines in Essex County and the city of Paterson, Democrat strongholds, one New Jersey native in the Fourth Circuit, and in the Commonwealth of Virginia, where Republicans had triumphed in all 3 statewide races, surprising many across the nation, quietly advanced in litigation never covered by the press, brought against the controversial masking mandates. Having had his case dismissed by the U.S. District Court for the Eastern District of Virginia in Richmond on a claim that he had failed to present a justiciable issue back in August of 2020, a rationale that tragically may be used to justify the dismissal of the overwhelming majority of cases brought by pro se litigants, who tend to file unmeritable claims or weak cases in court, lacking formal law school training. In fact, the petition for certiorari presented by Bond, which raised the issue regarding the deficiency of the lower courts articulating a reason for the dismissal of the complaint, as they are often very, very sparse in providing reasons, was denied, even presented with the assistance of Boies and Posner, 2 legal powerhouses, because even that petition had somehow failed to contain the exact deficiencies about which assignments of error were brought that had been noted in the record, and had indicated that very few pro se litigants can parse the record and identify how to amend their complaints. Over half of the petitions for writ of certiorari from what the federal courts review has estimated to be over 1 million cases each year that are commenced by pro se litigants in the lower federal courts are drafted by those persons who tend to be indigent parties, and over 70% of whom tend to be inmates in federal prisons. Again, we're talking probably a very, very progressive constituency, with an average of 3.28% in success for criminal defendants, very low, between the years 2014 and 2017. While civil litigants had a success rate at being granted certiorari of only about 2.28%. In 2010, back in the Obama administration, according to the Supreme Court press, only 165, or 2.8% of the petitions for writ of certiorari filed from a total of 5,910 petitions were docketed by the United States Supreme Court. But chances improved to 6% success rate for litigants represented by counsel, where, in accordance with Rule 10 at the Supreme Court, review on a writ of certiorari is not a matter of right, but of judicial discretion. A petition for writ of certiorari will be granted only for compelling reasons. According to the rule, a grant of certiorari may be granted only where A United States Court of Appeals has entered a decision in conflict with the decision of another United States Court of Appeals on the same important matter, has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or has so far departed from the accepted and usual course of judicial proceedings, or sanctioned such a departure by a lower court as to call for an exercise of this court's supervisory power. B, a state court of last resort has decided an important federal question in a way that conflicts with the decision of another state of last resort or of a United States Court of Appeals. C, a state court or a United States Court of Appeals has decided an important question of federal law that has not been but should be settled by this court, or has decided an important federal question in a way that conflicts with relevant decisions of this court. And that rule states that a petition for a writ of certiorari is rarely granted when the asserted error consists of erroneous factual findings or the misapplication of a properly stated rule of law. Trends in pro se litigation indicate that the rate of pro se litigation amongst criminal defendants is on the rise in recent years, which are over 70% of the cases commenced in the federal courts. But for civil litigation commenced by pro se litigants who are plaintiffs, the clear majority of these cases tend to raise issues, not surprisingly, regarding civil rights, accounting for about 32% of the cases brought by unrepresented litigants in the courts for civil matters. And many scholars suggest that these inartfully pleaded cases suffer defeat because they are not strong cases at all, that a law firm might not want to accept even on a contingency basis, a purely business decision. However, those familiar with claims brought about rights under 42 U.S.C. Section 1983, there is another business reason why a law firm may not desire to take on these cases, or a litigant may not be incentivized to retain counsel, since they may expect only to recover the reasonable legal fees and fees expended for expert witnesses. That is the value of your rights in court. For a law firm, it is neither a gain and potentially a loss to the bottom line. And for a litigant, he can only expect to have his or her rights recognized by the court with no financial gain and purely only a moral victory at best. But on June 2nd, 2020, just 4 days after the facial coverings mandate took effect in the Commonwealth of Virginia, we brought suit against the facial coverings mandates on the basis of a legal theory that had commenced in the often cited precedent of Jacobson v. Massachusetts, a 1905 opinion drafted by Justice Harlan for the United States Supreme Court, a challenge brought against a $5 criminal fine that had been imposed against Pastor Henning Jacobson, a Swedish immigrant who had refused to abide by the smallpox vaccinations mandate in the city of Cambridge in that Commonwealth, a decision where Pastor Jacobson's two attorneys, Messengers Frederick H. Nash and Herbert Parker, for defendant in error, had brought a case for a criminal defendant without evidence nor expert opinions, with a dubious legal argument regarding a claim of rights guaranteed in the preamble that had been presumed to have been derogated, losing all the way to the highest court in the land. While, according to Justice Harlan, that case involved the validity under the Constitution of the United States of certain provisions in the statutes of Massachusetts relating to vaccination, nonetheless, the justice made it very clear that he would pass without further discussion the suggestion that the above section of the statute is opposed to the spirit of the Constitution. Quoting Chief Justice Marshall speaking for the court in Sturgis v. Crowninshield, where he had said that the spirit of an instrument, especially of a constitution, is to be respected, not less than its letter, yet the spirit is to be collected chiefly from its words. A very, very conservative reading of the Constitution. And in that most often cited opinion during the current public health crisis, Justice Harlan made it very clear at the outset that no power can be exerted to that end by the United States unless it be found in some express delegation of power or in some power to be properly implied therefrom. And quoting Mugler v. Kansas, an opinion he had drafted in 1887, Justice Harlan stated, if a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is beyond all question a plain, palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge and thereby give effect to the Constitution. Basically saying, yes, it is about your rights. This is a statement clearly an opposite to those who have argued that in pandemic, it is not about your rights. However, since at least 1984, the most often cited case in the realm of regulatory deference doctrine has been the decision by the nation's highest court in Chevron USA v. NRDC, a case with which most progressives should be familiar and penned by Justice Stevens, where the High Court had laid down the rule that the court had long recognized that considerable weight should be accorded to an executive department's construction of a statutory scheme it is entrusted to administer. And the principle of deference to administrative interpretations has been consistently followed by this court whenever a decision as to the meaning or reach of a statute has involved reconciling conflicting policies, and a full understanding of the force of the statutory policy in the given situation has depended upon more than ordinary knowledge respecting the matters subjected to agency regulations. And quoting U.S. v. Schimmer, another opinion authored by Justice Harlan from 1964, Justice Stevens said that if this choice represents a reasonable accommodation of conflicting policies that were committed to the agency's care by the statute, we should not disturb it unless it appears from the statute or its legislative history that the accommodation is not one that Congress would have sanctioned. Attorneys call this regulatory deference doctrine. Governor Northam made it unequivocally clear to a group of Fairfax Democrats in June of 2020 that he well understood the meaning of the Supreme Court decision in DHS v. Board of Regents for the University of California, which he had described to that audience as a DACA case, and called for 2 rounds of applause to make sure that everyone understood, as he did. And that decision had held, quoting Michigan v. EPA, a 2015 opinion authored by Justice Scalia, that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, classified at the time. But on May 26, 2020, when he had issued Executive Order 63, mandating the wearing of non-medical grade facial coverings, the only credible study on these prevention measures had been published over a decade before by the NIOSH in the Obama administration, which had determined, using the very same diagnostic equipment that is used to rate the N95 and other medical grade protective equipment, that the results obtained in the studies show that common fabric may provide only marginal protection against nanoparticles, including those in the size ranges of virus-containing particles in exhaled breath. In the face of this empirical determination, Governor Northam was not hesitant to state, as recorded by Blue Virginia on May 26, 2020, that they don't need to be medical grade. You can make your own. All you need is a piece of cloth and some rubber bands. You can even grab a bandana, a proposition that had even been rejected by the New York Times. Had that study been somehow defective, there would have been no reason for Dr. Anthony Fauci to state to CBS News on May 17, 2020, that CDC's updated mask guidance is based on the evolution of the science. For Dr. Northam to tell WJLA on May 26, 2020 that I am taking this step because science increasingly shows us that virus spreads less easily when everyone is wearing face coverings. Or for Clark Mercer, Northam's chief of staff, to tell the Washington Post on May 30th, 2020, there is no roadmap for closing or reopening an entire economy, particularly in the absence of federal support, guidelines, and constantly evolving science. since, as Dr. Northam has stated, he well understood the rule established by the United States Supreme Court was that judicial review of agency action is limited to the grounds that the agency invoked when it took the action, classified at the time. Prior to commencing litigation and due diligence, we had presented a request for documents under the Virginia Freedom of Information Act to determine as to whether Dr. Northam had any scientific reports to substantiate his claims based on his medical knowledge, or so he said, that non-medical grade facial coverings might in any way prevent the transmission of COVID-19. And we recovered only 2 scientific journal reports, poorly drafted, none of which presented any empirical evidence to support his claims, but only advocating for the implementation of the UNESCO precautionary principle, a theory that had been expressly rejected by American courts in the case of Sancho de Department of Energy, a case even referenced inside the Wikipedia citation that was included in one of those scientific research reports. And the only value arising from these mandates, according to those case studies used by Dr. Northam and Dr. Muhammad Norman Oliver to residents of Virginia, were feelings of efficacy and empowerment during times historically associated with fear, confusion, and despair. Therapeutic value only, nothing that is really going to prevent you from being infected by COVID-19. In addition to providing a symbol of the pandemic in constant reminder so as to reinforce the compulsion for compliance. Do it because everybody else is doing it. However, as the court poignantly observed in West Virginia State Board of Education v. Barnett, a 1943 case, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. And notwithstanding the clear guidance from the nation's highest court that whatever the power of the state to control public dissemination of ideas inimical to the public morality, it cannot constitutionally premise legislation on the desirability of controlling a person's private thoughts. That was Stanley v. Georgia, 1969. Under the First Amendment, Congress shall make no law respecting establishment of religion. And just as the founders understood that if angels were to govern men, neither external nor internal controls on government would be necessary, as stated in Federalist 51. They also recognize well that where annual elections end, tyranny begins, stated in Federalist 53. Accordingly, they comprehended well that our Constitution was made only for a moral and religious people, wholly inadequate to the government of any other, as John Adams stated to the Massachusetts militia on October 11, 1798. They well recognize that in a free government, the security for civil rights must be the same as for religious rights, and that it consists in the one case in the multiplicity of interests and in the other in the multiplicity of religious sects. At that, the degree of security in both cases will depend on the number of interests and sects, and this may be presumed to depend on the extent of the country and number of people comprehended under the same government. Federalist 51, James Madison, February 8, 1788. Accordingly, the facial coverings mandate, with legal effect, attempts to alter the minds and consciences of men, which is really the realm of the churches. My name is Major Mike Webb. This briefing is unclassified, as you were. Let's keep Mike Webb away from our schools. Honest. Carry on. This advertisement was authorized by Mike Webb.
Thunk, I could have had a vaccine.